I suppose what's at issue here is the way in which these standing orders must be adopted. And I have agreed to that personally, that they should be adopted. They need to be adopted in order to facilitate the continuation of the inquiry. But what is at issue here is the manner in which the inquiry will proceed now on foot of the necessary amendment of the Central Bank Act, having regard to EU directives, and the variance that will be between what the public expectation of the banking inquiry is and what the reality of the process will be from here on in. Now, my leader has spoken about the intentions of the standing order last week, and I'd like just to reiterate his genuine concerns. The standing order is consequent on the passing of the Central Bank Amendment Bill 2014 to facilitate the banking inquiry, which has, as I said, widespread public expectation of being open and transparent. But the standing order states that any member of either houses of the Oireachtas to whom confidential information is provided under subsection 5 and who fails to comply with the provisions of professional secrecy referred to in subsection 6 in respect of that information may be subject to the sanction of the House of which the person is a member, in accordance with rules and standing orders made by that House. This order is quite severe, and as Micheál Martin stated last week, he has received legal advice that confirms that the standing order is very restrictive on the members of the committee in terms of the sanctions they may incur if they are judged to have breached the Act in terms of receiving confidential information from the Central Bank and breaching their duty of professional secrecy. Given that the inquiry is meant to open up everything in the Central Bank documentation on corporations and individuals, it seems an extraordinary restriction. Even though this standing order was agreed by the CPP on legal advice, it actually creates a process for dealing with breaches of those professional secrecy obligations by members and provides for penalties where members do not comply with the requirements of the law. The standing order cannot be moved until the bill is signed, yet this issue was not discussed when the substantive bill was going through the Houses. It has become a latter-day requirement due to national and EU law on national secrecy. It is unfortunate that the approach of the government to the banking inquiry is so piecemeal, and it also exposes the fact that the model of the banking inquiry that the government selected is the wrong one. We need a far more transparent inquiry. We need to be transparent about what is allowable and what is not allowable, because the public has not got a clue about what is happening at present. We need to let the public be aware that certain personnel and documentation will not be made public via the banking inquiry. So it's not an inquiry that's going to be open, as I understand it, because of the restrictions placed on it. And I suppose it indicates that we're in an area of legal difficulty, that there's a quagmire arising here, that the information that the public might expect to get from a critical player in all of this, the central bank, is in fact going to be protected. As of necessity, it would appear, or we wouldn't get any information at all, but it's going to be protected by a series of EU directives, and that in turn has required us to amend our Central Bank Act, which in turn requires the House to come in here and look at standing orders, which also must be amended, or no information at all will be provided. So I suppose what we're saying here, Lascam Corla, is that there is a big divergence between the public expectation of what will emerge from the banking inquiry and the reality of the limited access to information that will be available as a result of the constraints that are placed on the banking inquiry, emanating, it would seem, in large part from EU directives. And if politically, I suppose we have some difficulty with that, and we have, that political difficulty derives from the fact that at no point in the initiation of this legislation or in the initiation of the debate around the banking inquiry was it signalled that the central bank was to have this unique degree of protection and secrecy applying to itself, to its staff, to those who have contracted to it, and indeed to its dealings with any body, corporate or unincorporated. I think that presents real difficulty. I do accept at the end of the day that given where the inquiry is going, given the work that has been undertaken, if it is to complete its work and have any engagement at all with the central bank, then the central bank amendment bill had to be passed. And I agree as well that while I have concerns about the strict nature of the constraints envisaged in these standing orders, that some amendment to standing orders will also have to be passed.